As are we, Your Honor.
Hi, we are now back on the record, and I just wanted to make a statement before closing arguments proceed. While we had the 10-minute break that counsel requested to prepare for closing, the court did watch the audio file from Exhibit C that both counsel know has been admitted as an exhibit. Thank you. Please proceed.
Good afternoon, Your Honor. Thank you for the opportunity. Mr. Baptista, thank you for the opportunity to make the closing arguments in the case. Your Honor, very respectfully, this is a case that we're looking at simply the best interest of the minor child. Is it better for Emma, considering the circumstances, to live in Missouri or to live out here in Nevada, at Las Vegas? And we'd ask the court to consider the following: that in April of 2020, Judge Brown at that time told my client to file a motion for relocation. And he in fact did that, and that's specifically in the record. There's no reason to argue it. It's, I believe, in the minutes and in the order. So he went ahead and filed a motion for a relocation, and the court granted a trial in this. So he showed right at the very first motion that he had a prima facie case. The court could have said, you don't have a prima facie case, you don't have grounds under room to move. But the court didn't believe that. And the parties were sent to mediation despite a record here, Your Honor, that would suggest, which concluded with no agreements. Your Honor, what the evidence has shown today is, when we go through these different factors, that one, Emma is of an age sufficient to probably state some kind of intelligent preference as to her custody, but certainly it wouldn't be the kind of preference that the court would have to rely upon under the statute. What we're looking at, of course, is 125C00354. As the court knows, Your Honor, neither party has been named a guardian for the child, so that is not an applicable prong for the court to consider. What is a very, very applicable prong for this court to consider is whether one parent is more likely to allow a child to have frequent associations and a continuing relationship with the non-custodial parent. And there, Your Honor, this has a long, very detailed, documented history going back to Missouri in the very first orders. And from the very beginning, Your Honor, the plaintiff in this case has denigrated father. She's done everything possible to marginalize him as a father. You heard me ask questions of her today. Is he a good dad? She wouldn't answer the question, said she didn't know whether he was a good dad or not, didn't offer any kind of opinion as to whether he had any good traits as a father. Not one, right? And what was the evidence that's been throughout this case, right, all the way through until today, is that mother does everything she can to interfere and limit father's custodial time and his relationship with his child, Emma. And there's no corresponding, right? There's never been a finding or any evidence that my client retaliates in that regard, that he prevents mom from having time with the child, that he denigrates mom to the child, that he makes false allegations about the mother to any third party. None of that. There's absolutely not anything in the record. I'm asking the court to think a little bit about just what we're able to prove today. Why did Dad not get birthday time in 2019 and 2020? For 2019, her story was, there was some kind of mix-up, even though the talking parent shows otherwise. There was some kind of mix-up at the exam, and yeah, I gave him the time that the appointment was supposed to be, and yeah, he's supposed to be in charge of all the medical appointments, and yes, he did notify me that he was going to be there, but the appointment went before it was supposed to occur. And then later we look back at page stamp 425 in Exhibit AA, and the bottom line is, because it doesn't say that you're going to get birthday time, I'm not going to give you any birthday time unless you accede to a whole list of my demands. And she wouldn't even let that with you, you asked her some specific questions. You can see right on page stamp 425 what the motive was, and the modus operandi as well. What happened in 2020? This is her story. You can't, because of COVID-19, which on the one hand she claims that she's so concerned with, yet unilaterally on her own, with no input from my client, right, despite having joint legal custody, custody. The first minute she could sign up, she knew exactly what she was doing. She signed up for a hybrid program, so the child, Emma, would be in class half the time, and then use that as an argument, which you can see right in their pleadings to this court, the motions and oppositions. They use it as a weapon to then say, well, no, you can't have time in Missouri because you're going to be in school, right? So it wasn't done in good faith. It was done unilaterally. It was done over my client's objection when he complained about it later. I want to walk the court through specifically the birthday this year, 2020. No. She can't fly out there, even though she's flown repeatedly as an unaccompanied minor, and we never heard any explanation as to how it would be any different, right, in my client's birthday in September than when it was less than a month later when she took the child out to go to, wait for it, Your Honor, a festival, right? On the one hand, she says, oh, no, I'm really worried about COVID, yet I want the child in face-to-face school, and I'm going to fly out in an airplane to go to a festival out in Missouri, and honestly live with other family members that are not direct family members in a house with a number of people. So, respectfully, Ryan, that was a really a red herring, nonsense argument to make. My client asked repeatedly, because he's out in Missouri, to have the information about the school. I won't belabor it. You can see the talking parents. Everyone agrees that all the communication is done through talking parents. There is no other form of communication. She wasn't cooperative. Even when she had things that she could easily give him, her position was, go call the school and figure it out. You know, give me the password, get off the passcode. Zero cooperation. Zero. None. And took the position, Your Honor, and again, you can read you can read this case, or read it in the case, completely prevented him from having any visitation outside the state of Nevada whatsoever. Nobody lived in Missouri and was working full time, right? Completely prevented it. We had to go in over her objection and get the judge to order it. I'd also respectfully suggest, Your Honor, when you look at this, that the judge did grant him quite a bit of time. The judge did what she could to split the summer pretty equally, and then gave him a whole month. And in December, we were supposed to be in trial initially. So he would have had what was very much approximating half the time. Then the judge kicked the trial until this date, and he had time at Christmas, which was a month later. But respectfully, Your Honor, when you look at the facts of this case, there's no question that he's the person most likely to facilitate that relationship. Let's also talk about, Your Honor, and this goes to the second level, the level of conflict between the parents, but also to the first one about this level of cooperation. She wants you to believe, this is her position in the case, that if you rule today that Emma is better off living in Missouri with, dad making $100,000 a year and mom being able to relocate to Missouri, making the same money that she's making here, right? Because she didn't learn to be a hygienist here, she learned it in Arkansas. There's no way that I'm going back to Missouri. Well, Your Honor, first of all, she has dozens and dozens of close family members that live all around Missouri. She admits that there were previous discussions about Missouri. In talking to parents on Base Stamp 395, in it she says, we would like to move from Las Vegas, Nevada. And I respectfully suggest to the court, Your Honor, that if this court orders this relocation, she'll be in Missouri in 8 weeks to at most 3 months. And how do we know that? Because in the last time, way back when the court in Missouri said, look, we're going to do this on and off schedule, but when school begins for this young child, when Emma goes to school age, the school is going to be in Las Vegas, Nevada with father. She was on a plane out here within, we say 8 weeks, she's saying 4 months. But in short order, no question about it, domesticated her order, and then went to court and fought to get more and more time than what was even awarded. And that's exactly what's going to happen in this case. Additionally, Your Honor, does Emma like Missouri? It drew all kinds of objections. Oh, we don't know. They know. She knows. She's been bringing the child to Missouri on a regular basis, over and over again, multiple times, 3 to 5 times a year, even in the few years that they've been here in Nevada. And probably most reflective and illustrative of how she feels about Missouri, Your Honor, is she refers to Missouri multiple times in her testimony as home. And I asked the court to consider that, because that's what my client considered. He thought this was great. He thought that she was all on board for this, because now he's making what she's making, right? Everyone's going to provide more for their daughter, and it's her home, right? And she told me that herself. Let's talk a little bit about the level of conflict. It's obviously high. You can see that in here. Whether you're going to claim that my client caused it or not, he has sensed some frustration, but the few examples that he's confronted with said she was a hypocrite. There was no four-letter words. There was no flying off the handles on rants or anything else. He got frustrated because, on the one hand, she admits that she enrolled the child in the Mozart program. Didn't give him any information about it. And then said, well, if you had been out there trolling and doing your own investigation, you would have found out. That's what she told you, that I enrolled the child. But when I asked her, well, how would you feel if he did that? And she said, well, I would be acting as the employee, right? So she knew what she was doing and what she continues to do. And, Your Honor, parenting from a distance is going to be difficult in this case, very difficult given the level of communication. We're asking that you consider those two factors, the level of conflict and who's really causing that conflict, him or her. On the one hand, they're exchanging out in Missouri. They claim to you today, we're going to provide no evidence that there were COVID restrictions, that she was locked down and not working. Her own testimony was that her dental practice was locked down and not working. So we have two people, my client making marginal money out here in Nevada in the middle of a pandemic, and her place closed down, and him with an offer for $100,000. So I don't know how, and working for $100,000, how would anybody argue he wasn't acting in good faith at all times? And by the way, when he got very short notice in the court, he hired an attorney in less than 24 hours, and he appeared and he obeyed all the court orders. And then they try to imply that supposedly he made her drive out here to Missouri and pick up the child. She drove to Missouri for her own volition, and he's paid for all the transportation since. Your Honor, as to the mental and physical health of the parties, Your Honor, there is nothing that there's nothing here to suggest that either parent can't parent Emma or suffers from any significant health issues that would prevent that or impede that. When we look at the emotional needs of the child, Your Honor, we have the court to consider that pretty closely in this particular case. My client was not in favor, right? He wasn't in favor of the legacy school. And we know that the child had problems with the legacy school based on plaintiff's own testimony and her own talking parents' statements, right? But when my client says, hey, look, she's doing well as she is, everything's going well, she'll take it to court, right? She'll take it to court as quickly as she can. And by the way, I'd like to bring that to your attention. When you look at who's filing all the motions in this case, they imply it's my client. That's not true. They were in Missouri and had a court order. She came out here and couldn't live with that court order. She's the one that took it to court in 2018. And then she's the one that took him back in 2020, right? She's the one that's arguing for these schools in multiple hearings and then caused them to have to file and get visitation outside the state of Nevada, right? And then they say, oh, well, look, he's just trying to get his daughter all the time. But we're right. We'd ask the court to consider that, Your Honor, when we look at the issue of the relationship with the parents, Your Honor. My client has a very close, loving relationship with Emma. You heard about the many fun things that he does with Emma, but also the school things that he does with her. You heard from his boss who flew out here at his own expense and testified about what he's seen in terms of interaction between my client and Emma. My client is remarried, or actually is married in this case, and Emily, his wife, takes care of their child when he's working. Let's talk a little bit about that line as to what is going on. Look, there's no question in preparation for this litigation, right, as part of a plan in this litigation, she had her mother come out to a state that she doesn't live in, right, out from Missouri, come out here and take care of Emma when she's at work all day. And when you ask her, well, what's the plan going to be going forward, right, no answer. I would suggest to the court, I'm not sure exactly how to address that, but whether there really is a plan or not, it sounds strange that there be no plan, but prior to Grandma coming out here from Missouri, the plan was we have a child in daycare early in the morning, babysitters picking up after school, and then keeping until later in the evening. That was the plan. That's what she was doing, right? She doesn't have any family out here. Neither does have any family out here. There are no ties out here whatsoever. None. Period. Neither have roots here. And her own statement was, right, in March of 2020, her own statement on Talking Parents was, Emma and I would love to move from here. That's what it says. We have no problem moving from here. So the newfound love for Las Vegas, Nevada is just that. And we suggest to you that as soon as this case is over, if Emma is not relocated to Missouri, what's going to happen is Grandma's not going to keep living here full time. That's not going to happen. And they didn't suggest that it was, and they didn't have Grandma testify that's what's going to happen. So it's back to daycare for Emma from early in the morning until late at night, 5 days a week. That's what's going to happen. As opposed to what would happen in Missouri. In Missouri, what's going to happen? The parties can continue to share a joint physical custody arrangement, which has never been changed. Grandma lives in Carthage, Missouri. My client's not necessarily opposed, and you heard him, is not necessarily opposed to living in Carthage, Missouri. He certainly doesn't live that far away, about an hour in Nexa. And these parties could, Your Honor, and you see this all the time where the parties exchange where kids go to Boulder High School, but they live in Henderson, and they continue to share joint physical custody. It's a very doable plan. And we would suggest to you that common sense would say that her returning home would be in the child's best interest, but certainly would endear her to the grandparents, all of whom live in Carthage. In addition to that, Your Honor, there's no history of neglect of the child or sibling of the child. I would suggest to you, Your Honor, that there's a long history which you can read about in the Missouri paperwork, and then it resurfaced in 2018, that there's always allegations that something's going on. The most recent one was that somehow in my client's care, the child fractured her ankle. False, right? My client is iced out of the appointments. None of them happened by FaceTime, even though we take 1 second to put them on FaceTime, right? Just get on FaceTime and roll it out there, right? Iced out all those, and sure enough, the objective evidence that she never communicated to my client, he had to go get the records himself and heard about that, was that the child never had a fractured ankle. And that's just one of the long line of allegations, Your Honor, that you can see in all the previous paperwork going back, beard rash, ring worms, sexual abuse, all these different things. We'd ask, Your Honor, the court to consider that neither party has any history of domestic violence. My client's never been charged with domestic violence or any other issues whatsoever in past background checks, and we're not claiming that she's committed domestic violence. We're asking, Your Honor, to consider the advantages in Missouri. And here, granted, the court has to consider some subjective facts. Now, one of the things that is important, Your Honor, is where is a child going to grow up in the best financial circumstances overall? It's no secret that children that live in an environment where their needs are being met more than at a marginal level of $18 an hour and going back and forth, that kids do a little bit better. They do, in fact, quite a bit better. And my client, Your Honor, if he could make $100,000 a year here in Las Vegas, he would have taken a job making $100,000 a year in Las Vegas, Nevada. He would have taken it. This was dropped in his lap, basically a once-in-a-lifetime situation for him. We have supplied the court with his 2016, 17, 18, and 19 tax returns, and he's never on his own ever made anything close to $100,000. And there's nothing to suggest, Your Honor, that as soon as she moves back to Missouri, her home, she's going to go ahead and make $43, $44, $45 an hour. No problem in any way, shape, or form, just like she did when she came out here. She's making basically the same money she's always made out here if you look at her own testimony and her answers to interrogatories, which I guess we didn't make an exhibit. Your Honor, we asked the court to look at the love and affection and just the overall environment of living in Missouri as opposed to here. The court, it can always be disputed about whether it's better to live in a smaller environment or a larger environment. Look, it's always in dispute. But I would just say this. The most compelling thing I'd ask the court to consider is her own statement. Her own statement was, we would like, Emma and I would like to leave Las Vegas, Nevada. It was a stated intent. So, Your Honor, looking at all those issues, we'd ask, Your Honor, that you make the following order that it is in the minor child's best interest to relocate to Nixa. We have no problem, Your Honor, finishing the school year, which is all online, and it's going to continue to be for the foreseeable future. And we'd ask, Your Honor, that you would award, if the plaintiff in this case somehow takes a different route than she did last time, doesn't move back, then we'd ask that you would give her, Your Honor, what we outlined in our pretrial, which would be 6 weeks of visitation in the summer, that she would have every other Thanksgiving, she'd have half of Christmas each year, and that she would have every spring break. And of course, which she won't apparently really talk about today, if she's out in Missouri on one of these 3 or 4 or 5 trips that she takes a year, and she's out in Carthage, Missouri, like she was in April of 2020, she can have additional time out there with some notice. We have no problem with that. So with that, Your Honor, we leave it to you to make the decisions in this case. We understand that these are always hard decisions. We're asking that you look at the overall situation for Emma, not favoring one parent or another just because of their, role as a mom versus a dad, but to look at really those issues of who is not going to be the gatekeeper here, right? Who's going to facilitate that relationship and how is it best handled? And with that, Your Honor, we leave it to you.
Mr. Everman?
Your Honor, when this evidentiary hearing began, we talked about what Father's plan was. Hey, Mom and the child uprooted themselves to move all the way to Nevada for Dad once. Why not force them to do so again? And that seems to be the major crux of what Dad's position is in this case. I want to note some things on the outset that Mr. Kelleher just brought up, in order to make sure that the court is hearing a corrected record. The motions that Mother has filed have been for enforcement. The motion that she filed when this case was initiated was to make sure that the Missouri court orders were being followed and that they would be workable for the parties given the new situation. The motion that she filed, which was an ex parte motion for return of the child, was filed not to extend litigation, but to enforce the orders and make sure that a child who was withheld for 2-3 weeks would finally be returned in accordance with the court's orders. I want to address also briefly the fact of the mom having a babysitter for the child. The parties both used babysitters for the child. Now Dad is saying that his wife will be watching the child, but we heard earlier that Dad and his wife were separated for a time here, for a sudden separation, which forced Dad at that point to move from place to place to place, staying in each place for 30 to 45 days at a time. That is not a reliable child care solution at this point. That separation only took place within the past 24 months. So to say that this is a stable daycare plan would be to ignore what has happened already with that plan in the past. We have heard a lot about how Mom doesn't have as many FaceTimes with Dad and the doctors as Dad would like. Although Mom testified that she does in fact many times provide those, just not every time. We want to note, though, that there is no evidence, nor any testimony by Dad, that Dad, after those appointments that Mom, in the record, told him about, there's no testimony, no evidence that he thereafter doctor reached out to any of the doctors, either prior to the appointments to see whether it was okay with the doctors to have FaceTime, and no contact from dad to those doctors or to the school requesting that information that he says, mom doesn't give him. Right? We heard that again with the babysitters. Mom gave him the names and a manner in which he can get the information that he wanted, and no evidence that he ever actually went about trying to get that information. Not even a motion filed with the court over that period of time saying that somehow mom didn't do what she was supposed to do. So these issues aren't so much dad's actual concerns. These are litigation postures. And I think one of the biggest evidences of that is the fact that dad has had decision-making authority for all of these doctor visits since the 2018 order, and then in the past 2 years he's taken the child to the doctor one time, and that's it. Really, though, this is a case about relocation. And it's a case about a relocation request made after father's wrongful retention in Missouri. So in April 2020, this court ordered the pickup of the child, finding that father had acted without permission or court order in taking the child, in keeping the child in Missouri with the intent of having the child reside there. 1 month later, his motion for relocation was filed. Now, we heard today from father that the Missouri job offer was not actually sudden. May have been a 30-day trial period, but father testified today that he was in talks for 6 months, and then he qualified that and said, well, months. Maybe not 6 months, but months. That was his testimony. So he knew where he was going. He knew when he would be going, but he hid that until January 2020, and just days prior to the wrongful retention, decided to tell mom that that move was permanent. Now, the applicable statute that we're looking at this under is NRS 125C.007. The burden, in this case, rests on father for his relocation. Father has been in communications with the Missouri employer for 6 months, at least several months. That would have been about October 2019 that he knew of this possible job in Missouri. Now, good faith reason for a move. Someone that has a good faith reason for moving would start these discussions with the other parent early, not after a first pickup by order of the court. Now, the second portion of the analysis is whether the best interest of the child are served, and we'll discuss those factors shortly. For now, looking at subsection 1C, the testimony on the job from father's employers isn't particularly consistent. The business has had, although he says it's a solid business, he also admits that it's had slow periods. Father himself testified that he rarely works a full day, and that sometimes what he does with his time is just sit there and build furniture for the business. That was father's testimony. That is not the type of employment that one would say is likely to be ongoing at $100,000 a year. There's also no benefits, no health insurance being provided through this job as far as father's testimony and as far as the employer's testimony. And this is because, frankly, they've admitted that this business has been slow going. It's a fairly new business from someone who's got just barely, 6 years of experience in the field who is running this business. The fact of the matter is that the only basis for this move is that dad is now making $100,000 a year. However, in the exhibits provided and admitted to this court, we see that in 2019, father's household income was $75,790 for the year. So we also have to understand that in Missouri, there's state income taxes, which are not being taken out of his pay here. So now we start looking at a benefit that is diminishing in nature. The next factor, subsection 2A, whether the relocation is likely to improve the quality of the child and the parent. When we look at this factor, the objective measures are, Really, the school grades. The child is doing really well in school by both dad and mom's testimony. While, of course, the child has seen some sort of behavioral issues, if we can call it that, over the course of the pandemic, we heard mom's testimony that those issues were being addressed appropriately by the school. For all intents and purposes, the child is faring well here in Las Vegas, even while we go through a global pandemic. Father also presented no evidence as far as the quality of the schools in Nixa. He didn't testify about visiting the schools there. In fact, he testified about zero personal knowledge as far as the school for the child is concerned up there. A substantial portion of the child's life is going to be spent at the school, and we know nothing about what that school is like. Normally, when we're talking about changing a child's schooling, and we're looking at which school will be more appropriate and in the child's best interest, we would take a look at the Arcella factors. In this case, with a relocation and a change in school, this request is naturally including a forced change in that school. So the Arcella factors are necessary for the court to adduce before saying that the child should be changed to a completely new school. And unfortunately, God has provided no facts upon which to review the Arcella factors. As far as father's motives in relocating and whether or not they're honorable. So the planning involved by father includes long communications with the Missouri employer, a move from Nevada to Missouri in March 2020, and then a wrongful retention of the child in Missouri. None of those steps involved discussions with mother, a letter requesting relocation. An honorable attempt would have included a truthful approach to this relocation request. As far as subsection 2C, whether the relocating parent will comply with substitute visitation orders. Father admitted that he's violated the mutual behavior order. He admitted to using rude language, and father stated that, well, so mom did too, and that his attorney would show us the evidence of that. However, no evidence of mother violating the mutual behavior order was ever presented. The recording of that is telling. Now, father testified, no, I've never recorded a telephone conversation because, of course, that would be in violation of the court's orders. The court has reviewed that recording, and we believe it's fairly clear that it's a recorded phone call. The child talks about how, they say goodnight to each other. Dad looks forward to her going up to Missouri in the future. This is not an in-person conversation. This is a recorded telephone call. Maybe the most egregious, of course, of the violations of the court's orders is the abduction and necessary pickup order. I take a moment now to point out that father's reasoning for withholding the child was a supposed concern about COVID and the child, and yet we hear in his testimony and in the testimony of his employer that he's having barbecues with 12 to 30 people at a time. There's been sleepovers at his house. Father blatantly violated the court's order in withholding this child, and he did so knowing that he would have to be in front of the court for a relocation request. So if he does that when he's under the purview of the court, what is going to happen when this case is over? Certainly, we have to wonder whether he's going to follow any orders at all. And he hasn't followed many other orders. The UNLV parenting course, ordered by Judge Brown in fall 2017, never took it. Reordered again in April 2018, never took it. Father admitted that he did not look into taking it until after he filed his relocation motion, which itself is another violation of the court's orders. Now, we also look at subsection 2D. Mother asserts that whether the motives of the non-relocating parent are honorable in refusing the relocation request. Mother testified that the child is doing well here, that she's happy here, that she's healthy here, that she's getting good grades. It's a happy child living with mom. she doesn't want this child uprooted yet again. And in fact, the court has really addressed the importance of having consistency in a child's life. Forcing this child to move every 3 or 4 years is certainly something that we need to take a hard look at before forcing it upon this child. A realistic opportunity to maintain a visitation schedule. Mother provided an alternate visitation plan in her opposition to the motion. Quite frankly, Your Honor, a liberal out-of-state visitation schedule is all that would be asked for. If Dad wants to come down and visit the child, I think provisions can be made for visitation down here in Las Vegas, Nevada. Frankly, a lot of this stuff could have been resolved, except that father refused to attend FMC mediation in the summer when the parties were originally ordered to do so. As it regards the standard best interest of the child factors, the wishes of the child, she's 9 years old. We would never want to force a 9-year-old to choose who she wants to live with. The child should not be interviewed, and the court should find that she has expressed no preference at this time. Any nomination of a parent or guardian beyond that they both have joint physical custody, neither parent has nominated any third party in this case to be a guardian. Which parent is more likely to allow the child frequent associations and continuing relationships? What we heard complained of is the fact that mother is following the court's orders. We heard Dad complaining that she wouldn't give him time during his birthday, but she made an offer to him consistent with the court's orders, saying, listen, I just want them, then give me 1 day to make up for that time, right? Mom doesn't have birthdays. So she had, I think it's perfectly reasonable to request a little bit of additional time. Dad refused it. And then he complains, well, why doesn't Mom do whatever I want her to do? The fact is that this factor favors mother. She has never withheld the child in contravention of a court order. Only father has done so as recently as April 2020. By definition, father is not more likely to promote the continuing relationship between mom and child. The level of conflict between the parents is very high, evidenced by the constant litigation and made no better by father's refusal to attend the UNLV parenting course. The ability of the parents to cooperate to meet the needs of the child. Quite frankly, the odd split of legal custody does promote some conflict. We believe that the parents should have an equal impact on the medical and dental decisions. That said, both parents should be doing their part, and even though Dad has had the ability and authority to make medical decisions, he's abrogated that authority altogether. He's never taken the child but once to go see a doctor since the 2018 order. Mother has a steady profession, a good paying job with benefits. She's been the active parent helping with the child for school and medical appointments. The mental and physical health of the parents, there's no evidence of either parent having any health issues except that father may suffer from some physical limitations as he testified to. The physical, developmental, and emotional needs of the child. Emma is a happy and healthy child. She's like any child at that age. She loves all of her family. She's got good grades. She has friends. Mother and Emma have extended friends here in Las Vegas. Emma sees more of Mother's family than she has seen of Father's family, though even in Missouri, Father won't take the child to go see Mom's side of the family. And Father testified that and qualified his visits as not being with family, but simply staying at the North Las Vegas house. Still, that family is here. The nature of the relationship between the child and each of the parents, we have no doubt that Emma loves both parents. Similarly, the ability of the child to maintain a relationship with any sibling is not applicable in this case. Any history of parental abuse or neglect of the child, there's no history of anything like that. No evidence of the same was presented. Dad wanted to dig up things that happened from prior to 2014, and the court rightfully rejected that. Domestic violence has not been alleged in this case. Whether either parent or any other person seeking physical custody has committed any act of abduction against the child. Now, evidence of abduction by clear and convincing evidence is required under 125C.00357. And this creates a rebuttable presumption against sole or joint physical custody for the perpetrator. It's not in the best interest of a child to be in the care of someone who has committed an act of abduction. Clear and convincing evidence is proof which persuades that the truth of the contentions is highly likely. Abduction has occurred in this case. The pickup order from April 2020 is evidence of that father wrongfully retained the child in Missouri in contravention of this court's orders. The facts have already been found by Judge Brown, therefore the rebuttable presumption has already been set. The burden, then, shifts to father, and he has admitted today that he held back the child. He's admitted to the wrongful retention. We ask finally, Your Honor, for attorney's fees in this case. We ask that the court allow us to provide the court with a Brunzell brief to address the necessary factors and the amount of fees expended. And we're asking for those fees because father initiated this case in violation of the court order. As a precondition to filing a motion for modification of custody, he was to complete the UNLV parenting class. He made no attempts of doing that. Father admitted at about 12:20 p.m. today that he did not take the course. He made no attempts to take the course. It was only after he filed his motion that he even looked into whether or not the course was available. We're also asking for attorney's fees, which were deferred for later proceedings by Judge Brown when she issued the pickup order. The court permits NRS 125C.0075 further permits the court to award fees for the non-relocating parent in the event that parent prevails. We thank the court for its consideration and patience today, and thank you, Your Honor.
Thank you, counsel.
Your Honor, and I'll just address a few points, and I won't take equal time.
You have 3 minutes, Mr. Kelleher. It's
okay, very respectfully, Your Honor. He looks to lead this court into error by trying to claim that our seller applies to the case. That would be flat-out error for the court to adopt that position. And number two, it's a red herring because his client could care less how good the schools are in Missouri. And we did provide tons of documents to her, which she said that she received, but chose not to read or look into. And we understand the hearsay rules. Unfortunately, my client's not in a position to fly an educational expert out from Missouri to testify or to testify otherwise. Number two, if the court looks at Exhibit AA, date stamp 322, just one of many examples. No, I know you're a manipulative jerk and harassment and attempt or grasping for strings to prove some point in court, and goes on and on about what a terrible person my client is. One of many examples. When she even bothered to respond, her own testimony is that at least half the time she didn't respond even to our family, to the talking parents. Didn't even give her a response. Number two, Your Honor, this argument that you didn't go to mediation, I want that really clear for the record. I think it might just be a mistake on the opposing counsel's side. My client attended mediation. He went to mediation and they didn't reach an agreement. So that idea that I want to make sure the record's clear on that, I think that's just a mistake on the opposing party side. He went to mediation.
I'm going to interrupt you, Mr. Kelleher. I actually read the Talking Parents exchange about it. It looks like mom attended a phone mediation, and then dad sent mom some messages that said, did you give them my phone number? Mom said, it's not my job to give them your phone number. And that was the exchange. And dad said, well, you could have given me your phone number.
She went and they tried to get in contact with my client, but apparently they weren't able to, and she didn't provide any information. My client did attend mediation, I believe, subsequent to that. So he made every attempt to go to mediation, although respectfully, look, they weren't going to resolve the case in mediation, right? It's a relocation case. So it's six, and given this history, it is what it is, but I just want to have it clear that he cooperated. He's been cooperating in this case. One last thing, Your Honor, and I know you gave me 3 minutes, I know you're busy, is the judge never found and could have found in this case that there was an abduction that met any of those statutory requirements in any way, shape, or form to have him arrested or charged in any way. And the judge, encouraged him to file a motion for relocation, which he promptly did, and the court granted a trial and found it a prima facie case. It's a preponderance of the evidence standard. That's all it's ever been, Your Honor. And if you grant my client's relief, she's moving back there because she doesn't like it here and she wants to move, and that's in her own statement. With that, Your Honor, I will leave it to you.
Your Honor, I do want to correct the record as far as the FMC. The parties were ordered to FMC 2 different times. Once in the summertime. Father never attempted to attend that mediation. They were ordered to go to mediation a second time to address the issue simply of the interim visitation schedule between the September filing and the coming back to court in December. That's the one Father attended. That's the one they're pointing to, Your Honor. Of course, the findings from the court and the orders of the court that are a record of this case regarding Father's wrongful withholding of the child, it speaks for itself. Thank you.
Thank you. The court is going to, well, I have one last question. I was considering doing my own written order, but I wanted to know if counsel wanted an opportunity to present a proposed order, or if they would decline that opportunity.
Your Honor, we would decline the opportunity and leave it to you because, and again, I'm willing to do whatever the court wants or opposing counsel feel strongly about it, but usually the orders, they never really comport with what the court's going to do anyway. So we would just ask the court to do it and issue a minute order or its own findings of fact and conclusions of law, Your Honor, respectfully.
Okay, thank you for that input. Mr. Ackerman?
If Your Honor has a decision and would like to place the decision on the record, we could then draft the order based off of that decision. I think that would may be helpful for the court if that's what the court's inclination was.
I would love to put a decision on the record. My problem is I need to review what happened in the other jurisdiction. I am so excited to put a decision on the record, but I need to review what happened over there first. I got a chance to review Exhibit Z while you guys were preparing your closing arguments, but I have not had a chance to look at all of the old prior orders, especially the ones from Missouri. So I need to do my due diligence with respect to that before I can place the findings and the conclusions on the record. So I'll do a written decision, okay?
Thank you, Your Honor.
Thank you, Your Honor.
Have a nice weekend,
Thank you all. I
everybody.
appreciate your time. Have a nice day.
Thank you, Your Honor. Bye-bye.